Bienvenidos and welcome everyone. And thank you so much for joining us today. My name is Montserrat Garibay, and I am the Eastern Region Representative and the Advocacy Chair for the National Association for Bilingual Education. Bienvenidos. And I will be your moderator for today's webinar. We're going to wait 2 minutes. If you can please put your name and the state that you're from and your title in the chat while we start. Thank you. This is great. We have people from lots of different places: Illinois, New York, California, Texas, Wisconsin, San Francisco, Maryland. Wonderful. So good to see everyone. Thank you all for joining us. And we want to be mindful of the time. And we have a lot to cover today. Again, we are very grateful that you're here today. And if you are having any trouble with the audio, please try to check your speakers settings and or reconnect to the webinar. Also, a great tip is to use headphones for the audio, a better audio experience. Okay, so this webinar is scheduled to run for 60 minutes, including time for a Q&A session at the end. And we have allocated time for those questions as well. So please submit any questions you have at the end in the bottom of the screen. And you can also use the chat box to share your thoughts. Well, please know that the Q&A feature is the best way to submit the questions for our speakers. And please note that the session is being recorded and that it's going to be transmitted in YouTube as well. And at the end of the webinar, we will have a survey as well. So again, thank you so much for participating in today's webinar. But before we dive into it, let's turn to our president, Doctora Margarita Machado Casas, who will share some remarks with you all. Margarita?
Muchas gracias, Montserrat. Buenos días, good afternoon. I'm not sure where you're at, but depending where you're at, buenos días or good afternoon, colegas, and welcome. On behalf of the National Association for Bilingual Education, it's not only my honor, but my privilege to welcome you to today's real critical webinar entitled The Impact and Consequences of Official English on Multilingual Learners. This moment calls for our full attention. I know all of you have seen media and everything that's been going on, and this decision to rescind this important guidance is not simply a technical or bureaucratic change. It's an attack on our rights and the rights of more than 5 million multilingual learners and their families across the United States, some of them in your classrooms. It threatens us and it rolls back decades of process and progress that we've had in ensuring that every student, regardless of their language and the language they speak, has equal access to excellent education. Why is it important to act now? Why is it so critical? Because language is not just a tool of communication, as you know, it is identity, it is culture, it is community. When our students are denied the right to learn in their languages, it's not only about educational barriers, not only about an educational barrier, but it's also an infringement on their freedom, their expression, and their civil rights. To silence a child in a child's language is to silence their voice. And we cannot and will not allow that to happen. So this is about the fundamental right to speak our language, to preserve them, and to pass them to future generations. It is about our right to free speech and to live authentically without being forced to abandon our language, our culture, our families, and our histories. And it's about the right to learn, to thrive and succeed in a society that values diversity rather than punishing it. We can't go back Too many sacrifices have been made and too much progress has been achieved for us to allow these protections to be dismantled. This is our urgent call to action. We have to stand firm. We have to push forward. We have to ensure that multilingual learners, bilingual learners are recognized, respected, and uplifted. The future we envision, one of equity, justice, and opportunity, depends on all of us. And I want to extend my heartfelt gratitude to our distinguished speakers from all the different states that are here, who have graciously given their time, their expertise, and their passion to guide us in this discussion. Your voices and your leadership, colegas, are critical as we chart this pathway. Thank you all for joining in this urgent fight for our students, our familias, and our communities, and for the fundamental right for us to speak our languages freely. Gracias, Monse.
Thank you, Margarita. Thank you, everyone, again. And we have a great list of speakers who have been doing this work and are very committed to it. So let's start. Please help me welcome Michael Piera with the Educational Opportunities Project and the Lawyers Committee for Civil Rights Under Law. I had the privilege of working with Michael during my time at the Department of Education. Michael, welcome.
Thank you, and good afternoon, everyone. So I'm going to start off with some background on the Dear Colleague letter. As many of you likely know, the Dear Colleague letter for students who are English learners and parents and guardians with limited English proficiency was issued jointly by the Department of Education and the Department of Justice in 2015. Typo on the slide there, sorry, 2015, not 2025. It has been a foundational document for more than a decade. Ed and DOJ guidance and technical assistance that came after this document reiterated points made in this document and added additional helpful insight on top of that. The Dear Colleague letter has been essential, essentially a one-stop shop for school communities to understand the legal rights for students who are ELs and parents and guardians with LEP. And since 2015, this has been the document that I provided to school districts, to parents, and to others whenever I was asked questions about what the law required. And again, I heard from everyone in school communities how helpful this document was in understanding the law. The Dear Colleague letter was specifically framed when it was issued as being a celebration of the 40th anniversary of LAU and the EEOA, and the 50th anniversary of Title VI of the Civil Rights Act. The Dear Colleague letter explains the legal requirements under Title VI, the EEOA, and Title III of the Elementary and Secondary Education Act. Can you flip to slide 2, please? And I believe David and others might cover this more, so I'm going to try to be brief here. But I want to be clear that this Dear Colleague letter did not make law. The department or DOJ rescinding or issuing Dear Colleague letters does not make law. This didn't make law, and their rescinding of it didn't make law. Instead, it just provided a helpful understanding of what existing law requires. The Dear Colleague letter can be traced from a 1970, that's how long this has been standing, a 1970 memo from the former U.S. Department of Health, Education, and Welfare, which was the predecessor to what is now the U.S. Department of Education. That memo was the initial guidance from the Department of Education, clarifying specifically that Title VI of the Civil Rights Act of 1964 requires schools to provide an equal educational opportunity for students who are English learners and provide guardians and parents with limited English proficiency adequate notification of school activities. And then in 1974, in Laos, the U.S. Supreme Court confirmed this understanding of Title VI that was explained in that memo. David will discuss, I think, Laos a little bit further, but this quote from Laos that I have here on the slide is essential framing for the Dear Colleague letter. So I've included it here, and it's sort of worth spending a moment on. Specifically, the Supreme Court said there is no equality of treatment merely by providing students with the same facilities, textbooks, teachers, and curriculum for students who do not understand English are effectively foreclosed from any meaningful education. And that same year, following the ruling in Laos, the Equal Educational Opportunities Act of 1974 was signed into law, which, among other things, specifically requires state and local education agencies to take appropriate action to overcome language barriers that impede equal participation by students in a school's instructional program. Can you switch to slide 3? Thank you. So what does the Dear Colleague letter say? It says specifically that both states and school districts have an obligation to ensure that programs for students who are English learners comply with federal civil rights laws. And it frames the legal standards under Title VI and the EEOA, which have similar legal requirements. Specifically, with respect to students, federal civil rights law requires elementary and secondary schools to provide appropriate language assistance services to students who are English learners that enable them to become proficient in English and participate equally and meaningfully in the standard instructional program within a reasonable period of time. And with respect to parents, federal civil rights law requires that elementary and secondary schools ensure meaningful communication with parents and guardians who have limited English proficiency in a language that they can understand. For example, schools may take steps to provide effective language assistance to parents and guardians by providing accurate written translations or oral interpretation. Slide 4, please. Thank you. Additionally, this Dear Colleague letter says that one of the most critical affirmative steps on appropriate actions that school districts must take to open instructional programs to students who are English learners and to address their limited English proficiency is to first identify students in need of language assistance services in a timely manner. Many schools do this in part through the use of a home language survey, and school districts must have procedures in place to determine if students are English learners through a valid and reliable English language proficiency assessment. And these assessments must assess the proficiency of students in all 4 domains of English. That is speaking, listening, reading, and writing. When English learner students are identified based on a valid and reliable assessment, school districts must provide them with appropriate language assistance services. Language assistance services are programs for students who are English learners, must be educationally sound in theory and effective in practice. They must be designed and reasonably calculated to enable students who are English learners to attain both English proficiency and parity of participation in the instructional program of schools. And school districts have an obligation to provide the personnel and resources necessary to effectively implement their chosen EL programs. This obligation includes having highly qualified teachers to provide language assistance services, trained administrators who can evaluate these teachers, and adequate and appropriate materials for EL programs. The Dear Colleague letter makes clear that EL programs may not unjustifiably segregate students on the basis of national origin or EL status. And finally, the Dear Colleague letter makes clear that Ed and DOJ have utilized an essential Fifth Circuit case, Castaneda, to determine whether or not a school's program complies with civil rights laws. And I think David's going to talk a little bit more about that in a minute. Can you switch to slide 5? Thank you. Over the years, the Department of Education has further elaborated on some of what was discussed in the Dear Colleague letter through additional fact sheets, many of which, as of now, have not been rescinded. One example is a fact sheet focused specifically on advanced coursework and specialized programs like AP, IB, Gifted and Talented, CTE, and dual enrollment. This fact sheet indicates that schools must ensure that eligibility for advanced and specialized programs, including appropriate evaluation and testing procedures, do not screen out students who are English learners because of their limited English proficiency, and that schools must provide appropriate language assistance services to students while participating in advanced or specialized programs. And the fact sheet also provides a list of detailed examples of the types of things that could constitute discrimination. Can you switch to slide 6, please? Another example of a fact sheet which provides additional guidance is an intersectional fact sheet for students who are both English learners and students with disabilities. That fact sheet makes clear that schools must provide students who are English learners and also have disabilities with both the EL services and disability-related services to which they are entitled under federal law. And schools must evaluate students who are English learners for a disability in an appropriate language based on the student's needs and language services. And similarly, students with disabilities must receive appropriate disability-related services when schools evaluate their English language proficiency. And this fact sheet also provides a number of examples of the kinds of practices that could raise concerns of discrimination, some of which I've included here on the slide. There are many more within the fact sheet itself. Can you switch to slide 7, please? And OCR and the Department of Justice also jointly issued a pair of fact sheets on protecting access to education for migratory children and for unaccompanied children. And these fact sheets made clear that public schools must be open to all students, regardless of their parent or guardian or sponsor's immigration status. The fact sheets focused on migratory children and unaccompanied children also reiterate that schools must provide meaningful and equal participation to students who are English learners and meaningful communication for parents and guardians who have limited English proficiency. And again, the fact sheets provide examples of the types of practices impacting these student populations that would raise civil rights concerns. Montserrat, I think I'm ready to pass it.
Thank you so much, Michael, for all the information. And we have also put in the chat a lot of the links that you referred to. So now we're moving to David Hinojosa, who has been a champion as well of the great work that happened over the several years when he was at Maldiv as well. But David, it's a pleasure to have you. Please go ahead.
Yeah, thanks so much, Montserrat and Margarita and Nabe for hosting this incredibly important webinar, at this time, this critical juncture. And it seems like, we've made so much progress, over the years, fighting for the right to bilingual education, to the right to dual language programs and the like. And people want to suggest that it should be a localized decision and what kind of programs you have. And then we have all these policies that are highly politicized, not looking out for the best interest of the children. And so we find ourselves, in this predicament, largely because of the election. It's not like things were going great for a lot of English learners. I think many had access, to incredible teachers. They had incredible access to resources, but there was still a lot of enforcement activity by the Office for Civil Rights, by the Department of Justice around deficient, language programs, whether it was on the resources or training side, materials side, et cetera. Lots of different problems associated. But now they're, compounded by the current administration. And, if we can go to the next slide, Lau v. Nichols is a case that Michael had mentioned. It was a case that the Youth Law Center, which is the predecessor to our current organization, the National Youth Law Center, helped litigate all the way to the Supreme Court, and that primarily concerned, a challenge in the early 1970s to San Francisco Unified School District policy to simply sink and swim Chinese students, Chinese American students in the public schools, not providing them for any language support, providing them with all English materials, et cetera. And so a lawsuit was filed on behalf of those students and alleging that they were being discriminated against, among other claims, but they were being discriminated against on the basis of their national origin because of the language discrimination. And the two lower courts had actually held against the plaintiffs challenge this, and then the Supreme Court held in favor, and that led to the Lau remedies that were mentioned previously, and really along with the Hugh 1970 memo that Michael mentioned, provided a foundation for what we had as the more recent guidance, as well as another executive order that was signed in 2000. So then you fast forward today, and there's EO 14224, which was the administration's designation of English as the official language of the United States. And together with that, there was the July 14th Attorney General Bondi memo that both, helped outline, the administration's intent to assimilate the population, to rid any services provided in languages other than English when they were provided, at the federal level and or, through supporting agencies and the like. But importantly, this does not mean that the that they can do anything that they want. Even the executive order says, that here's your marching orders, take back any prior LAP guidance regarding Title VI's prohibition against national origin discrimination affecting in their language limited English proficiency, conduct this internal review of all existing non-English services, redirect funds, to rush ahead English proficiency and assimilation, do all these activities, except as required by law. And of course, trying to figure that out, the guidance, helped us understand, what the law required. But even without the guidance, there still are other laws, especially for students in schools, English learners in schools. If we can go to the next slide. Part of that is the Equal Educational Opportunities Act, right? Many of you may be familiar with this. For those of you that are not, this is the language. And this is the language of the law that was passed in 1974, right around the same time that the Supreme Court was considering the Lau v. Nichols case. And it was attached to the Equal Educational Opportunities Act. The other provisions are kind of like these anti-busing desegregation provisions, but this provision was added around helping students overcome their language barriers. It doesn't require any specific language program, but what it does require, if we can go to the next page, is what we call the Castaneda framework, which was a case out of Texas against Raymondville school district there in the late 70s, early 80s. And this framework has been adopted. So what does it require? That the language program just can't be made up. It must be based on a sound educational theory or principles. That still provides a lot of latitude, right? But ideally, it's going to be supported, by some kind of research, and it certainly doesn't allow for sink or swim situations. The program must be implemented with the appropriate resources. Michael had mentioned about, teacher training. Sometimes if a state requires certain certification requirements, it'll require those, requires materials. So if you have a bilingual class, you have to have bilingual materials, right? And after a sufficient period of time, how much that time is it 3 years? Is it 5 years? We don't know specifically from the courts, but it still has to, after being provided a sufficient period of time, must show that it's actually helping students acquire English proficiency. If we can go to the next slide. So what is DOJ saying about this? There's actually a link here, and hopefully I'll provide these links if they haven't been provided already, in the chat after this. Because I certainly did not provide them to the organizers of the webinar. But, this is still on the DOJ's website. So yeah, you have the guidance taken down by the Department of Education. Department of Justice is different. Department of Justice is the agency that primarily enforces the EEOA, right? Title VI is enforced by both Department of Education, OCR, and DOJ, but DOJ is the primary enforcer of this federal law that is not impacted, by the EO or the Bondi memo. And so there's lots of things, that are still, being investigated by DOJ. On the next slide, and I'll wrap up. So what do you do? What can you do? Certainly you should always start, with a teacher and or principal just to make sure that you're understanding things, that people that you're working with are understanding things. You have to be aware whether or not they're trustworthy. File a complaint with the local school board consistent with your local board policy. That might be something that you could consider. You could file a state administrative complaint. Not all states have investigative bodies that investigate complaints. Some states, like New York State, has, a civil rights office, as well as, New Mexico, among others. but they may not have, much capacity to investigate. You can still file an administrative complaint, but you got to be wary, and likely seek, legal consultation, and contact a civil rights or legal aid organization for assistance. There aren't many that work in the education space. There are even fewer that work in language assistance, but I know that certainly myself at the National Center for Youth Law and others here, along with this program that we're trying to expand the capacity of people, including pro bono attorneys, that we're working hard on so we can extend enforcement, for many people encountering problems. Would be happy to talk with, local attorneys as well. So that's it for me. Thanks so much again, for inviting us.
Thank you so much, David. And thank you so much for those important recommendations that you provided as well. Next, we have Lina Lenis from Unidos US, and she was sharing updates about the National English Learner Roundtable and their collective efforts. Lina?
Thank you, Montserrat. Good afternoon, everyone. I'm Lina Lenis, Policy Analyst for K-12 Education at Unidos US. Unidos US, for those who don't know, is the nation's largest Hispanic civil rights and advocacy organization, and we are proud to co-chair the National English Learner Roundtable, which is composed of well over a dozen national and state-based organizations, including many on this call, NAVE, Californians Together, and TESOL, and we work in coalition to advance the education of our nation's more than 5 million English learners. So I'm here to discuss advocacy efforts underway on the topic of the rescinded guidance. The roundtable quickly came together to write a letter to Education Secretary Linda McMahon and Attorney General Pam Bondi to demand the immediate reinstatement of the 2015 Dear Colleague letter or guidance. I'd like to highlight that we did not ask for new or replacement guidance, but rather the reinstatement of this 2015 guidance, as we believe that this is the only course of action that will best serve our English learners. In the letter, we note that this rescission of guidance sends a dangerous and misleading signal to education agencies that the civil rights enforcement of more than 5 million English learners is optional, but let me tell you, it certainly is not. We emphasize that civil rights laws and Supreme Court decisions that underlie the guidance remain in full force and effect, and they bind all states, school districts, and schools to fulfill their legal obligations to English learners. We also emphasize in the letter the tangible on-the-ground impact that many of you are seeing and that states and school districts are facing. They're now unsure. How do they address common civil rights enforcement questions? Where do they find best practice advice, or how do they proactively prevent noncompliance? The letter also notes that the rescission of the guidance is counter to many of this administration's priorities. The administration says that it intends to return education to the states, but rescinding this 2015 guidance just leaves states and school districts vulnerable to litigation without any technical assistance. This administration also says it seeks to empower parents and advance parental rights, but then rescinded the guidance that helps schools identify how they can meaningfully communicate with limited English proficient parents, including about things like special education services, report cards, and parent-teacher conferences, thus denying parental choice in their children's education. We also note in the letter that while the administration focuses on, wants to refocus learning on math, reading, and science, history, but they rescinded the guidance that helps schools establish sound instructional programs to ensure their effectiveness in increasing English proficiency and academic achievement. I'm pleased to share with you that in just a matter of a few quick days, this letter got 130 signatures from organizations at the national, regional, and state level, and we sent it with such a robust show of support to the Education Department and the Department of Justice on September 12th, nearly 2 weeks ago. And also pleased to share with you that we, as the National English Learner Roundtable, are working closely with our champions in Congress. So Representative Jesus Chuy Garcia from Illinois' 4th District sent a similar letter just a day prior, signed by 80, that's right, 80 members of Congress to the Education Department and the Department of Justice, also demanding the reinstatement of the guidance. And a similar effort is being led in the Senate side by Senator Alex Padilla from California and Senator Catherine Cortez Masto. So the National English Learner Roundtable is very active right now in making sure that we send a strong, unified message to our leaders that we have noticed this and that this is not okay and that the only path forward is reinstating the 2015 guidance. Thank you.
Lina, thank you so much for the update. And indeed, the power of intentional collaboration is being shown by all the members and stakeholders of the EL National Roundtable. All right. Well, next we have Jeff Hutchinson with TESOL. Jeff, go ahead.
Thank you, thank you, Montserrat, and thank you to everyone here, not just the panelists that are coming together, bringing their information, experience to the challenge ahead of us, but also all of you out there that are attending this meeting, just showing your demonstrating your just your passion for this and service to the learners out there and support of educators and schools during this time. For those of you who don't know, TESOL International Association is we're coming up on our 60th year serving English language educators across the globe. We are very happy to be in coalition with the National English Learner Roundtable, especially working with NABE on this important task. Many of our state affiliates are also and joined with NABE affiliates in their advocacy efforts. As part of this advocacy year. Oh, and I didn't introduce myself. I'm Jeff Hutchison. I'm the director of advocacy and public policy for TESOL International Association. But part of our advocacy that we've been engaged in has not just included the collaboration and the coalition building with other organizations. It has also been reaching out to our state affiliates. It has also been providing grassroots campaigns for not just our members, but anyone involved in the public to take action and contacting their members of Congress. And we have also put out statements. So we put out statements on the English only executive order that minimized and pretty much dismantled the focus upon the assets that our English learners provide. And then again, when Attorney General Bondi put out the guidance on that executive order, which really denied language access to a lot of, I shouldn't say denied, made a path in which language access could be restricted or at least modified, put a statement out on that in support of our just access to public education for our multilingual learners of English at all levels, not just K through 12, but all levels. And then most recently, we put out a statement here direct to the rescission of the guidance. I won't go into great detail on what's on this because I think the speakers have already outlined very clearly the fact that despite the rescission of this guidance, the laws remain. This guidance does not take away, it does not implement laws. It just provides exactly that guidance on how these laws should be put in place. So the laws are still there. The guidance itself, while rescinded, still remains a valuable resource so that in your own advocacy at whether it's a local education agency, state education agency, what that may be, you can help I always hesitate falling back on the legal grounds because quite frankly, this is the moral grounds that we're talking about in service to our learners. And one of the things that we do have on this statement is talking about those laws, talking about the responsibilities of LEAs and SEAs, and most importantly, what you can do as an advocate. you realizing that you may not have access to litigation services or those kind of resources or funds, but there are things that you can do effectively on the ground and building your own coalition and support. And it all begins with making sure that you understand the context and understand not just the laws, the context of the laws that are out there, but understanding what your local school districts, what your state is doing. So we do have opportunity here a little bit more from a little bit later in this presentation what's happening locally in the state of Michigan, what they have been doing positively, but there's also states that are up against the wall here, and which we're having to be reactionary in just how states are approaching the civil rights of English learners. So encourage you all to go ahead and take a look at that, be an advocate. Feel free to reach out to me. My apologies, Matsurat, if you could put my email, I'll be very happy to talk with anyone who would like to discuss more on what you could do locally. But one of the key things is working locally with a state affiliate, whether it's a TESOL state affiliate, NABE state affiliate, making sure that you're building coalition there together. All right, so thank you very much. It was a very honor to be here. Thank you, Montserrat, for the invitation.
Thank you so much, Jeff. I really appreciate you joining us. And one of the things that as we were preparing for this webinar, we wanted to give everyone very specific tools so you can have them in your toolbox and prepare. So we also wanted to highlight some of the voices from the field. And now I'm very excited to introduce you to Marta Hernandez, who's not a stranger for us. She's with Californians Together. Marta, go ahead.
Thank you, Montserrat, and good morning or good afternoon, depending on where you live. I'm very honored to be here and have been invited to share some thoughts. I'd like to share just a little bit about Californians Together. We are a statewide coalition of 38 organizations committed to advancing the success of California's 1.1 million English learners. And in this role, we engage very deeply with networks of educators, county and district leaders, site administrators, and advocates across the state. And so I'd like to share today the feedback we are hearing from the field, how leaders are experiencing the consequences of the rescission of the Dear Colleague letter in their day-to-day work with English learners. And so the 2015 guidance, provided more than legal citations. It gave districts a clear roadmap for program design, staffing, data, and parent engagement. It helped translate the federal laws into concrete practice. District leaders could look at it and know, here are the guardrails, here's what compliance looks like. Without it, that shared baseline is gone, and implementation will become even more uneven across the country. In terms of program design, rescission removes the clarity districts need to build strong, equity-centered systems. Instead of having these clear guardrails and directions, leaders fear that they will be left guessing what compliance looks like. That uncertainty often leads to risk avoidance. We fear that leaders will play it safe by doing the minimum rather than building bold, equity-centered programs. English learner advocates in California see a risk of the adoption of generic programs that treat English learners like monolingual students, ignoring language access. In terms of staffing, there is a fear that this instability will undermine the pipelines that we've worked so hard to build. Districts are beginning to question whether to hire bilingual teachers and administrators or create new roles such as bilingual specialists when they are unsure whether expectations will shift. And for educators, what we are hearing is that they fear that the support and resources that they need will be halted and that there will be less continuity for students in the very support that they need most. When it comes to reporting, rescission causes confusion. Without clear metrics, districts are unsure what to track, how to disaggregate, or how compliance will be judged. And all of this really results in a real concern about liability. When federal protections are weakened, the burden shifts downward. And so states and districts are left to kind of interpret the federal laws without real clear direction. And so this legal ambiguity drives fear of litigation, and we fear that that will result in minimalist compliance. And so now at the local levels, this will require additional local advocacy to prevent rollbacks in services. And, we do see a great risk of inequity. There's district to district variation as it is, strong services in proactive districts, minimal services in others. And then we have small and rural districts with fewer resources, and they are especially vulnerable. Newcomer students and students in underrepresented language beyond Spanish, I think, really risk being overlooked. And you've heard it before that the rescission doesn't erase our moral or legal responsibility to English learners. Federal guidance doesn't replace the law, but it makes the law real for schools, families, and districts. And so without it, we risk confusion, inconsistency, and inequity. And our multilingual learners can't afford that. For local leaders, school boards, superintendents, program directors, the responsibility now is to be proactive. And that means using state frameworks as de facto guidance, investing in bilingual staffing, expanding biliteracy and ELD programs, and creating local monitoring systems for equity. The absence of federal clarity cannot become an excuse to scale back. It should be a call to lean in. And with that, I hand it back to Montserrat.
Thank you, Marta. Thank you so much for your leadership and for really speaking truth to power. I love that your message of being proactive and really asking states to create these frameworks to really protect our students. So thank you so much for that. Next, we have Pamela as well from Michigan, and she's also sharing very deep information about what's Michigan doing. So go ahead, Pam.
Hi, thank you so much. I'm Pam Scholier. I am the Director of EL and Bilingual Programs at West Ottawa Public Schools. And I really wanted to build off of what Martha shared there of what can we do? What can we do at the state level and the local level to be able to move our programs forward and opportunities forward for our students despite the uncertain times from the federal level? So my perspective currently in my role is at a single district in Michigan, but I really want to highlight the collaborative effort across the state and encourage each of you on this call, grab some friends and some colleagues across your state to be able to do this work together, because that's how we have moved things forward in Michigan. So it's been a collaboration between representation from MAVE, MyTESOL, the Michigan Department of Education, and many of our local leaders across programs across the state. I'll have you move to the next slide for me. So this actually did not start currently with the rescinding of the 2015 Dear Colleague letter. This journey actually started a few years ago. My own dissertation work was on school civil rights obligations to English learners in 2020, and we surveyed over 800 of our Michigan school and district leaders about their level of understanding and their level of implementation of those 10 civil rights obligations found in the Dear Colleague letter. So that really inspired a group of us, and we came together in February of 2023 at a NABE conference, and really we were dreaming of change, of if not us, who, and if not now, when. And so we went on this journey throughout Michigan, named stakeholders from all geographical regions, from institutions of higher education. We had the Michigan Department of Education, local leaders from low, medium, and high incidence districts to be able to come together and name some priorities. And we had shared advocacy tools. We did a lot of learning together, a lot of out of all of the pieces that we could advocate for, what are the big things that we needed? And so we created some shared advocacy tools and did see some big wins in Michigan recently that I'll share with you in a moment. And you'll see here as we continue the journey into fall 2025, despite the fact that we have some new hurdles in front of us, that we're continuing to look at our sphere of influence of what can we do collectively to be able to continue this work. So I'll highlight on the next slide a few of these tools that we've been using and hopefully encourage you as well. So we'll share the link to these slides, and you'll see the live link available there so you can see. So in Michigan, we have state level funding called Section 41. And as a group, we identified two really big needed priorities: funding for our English learners to move these programs forward, as well as clear policy. And we know the 2015 Dear Colleague letter provided that. However, in Michigan, we didn't have any specific policy beyond that, or very minimal. And so we had a shared proposal document that was shared across the state between EdTrust Midwest. We work with lobbyists and legislators, leaders across the state. And we also created an EL funding comparison. Some colleagues from Michigan State University worked to publish a document that you'll see in a moment through EPIC to compare funding across the state. And then we use my own district example as a leverage point to really display how districts are funding their EL programs and what that does as far as a general fund cost compared to what we might get from a state level fund like Section 41 in Michigan or a Title III, as we all spend much more on top of that. And so you see there a picture of a postcard, and that was one of our advocacy tools. At the MABE conference, we had over 500 people write handwritten postcards out with the common messaging there, and we mailed them all to our state legislators to help move this work forward. So I'll show you the next slide a moment. This is one of the advocacy tools, and I really just want to highlight the fact that this is a grassroots movement across the state of Michigan, that sometimes you feel like the change has to wait for an entity or someone bigger or a voice that's louder perhaps. And truly, this came to be because we had really passionate leaders across the state working together. So this was a common tool for advocacy that we worked on to name a vision, really clarify what the issues are, and name a really bold solution to move this work forward. So you can look at it more closely or follow up with me via email if you'd like afterwards. The next tool is on the next slide that we used. And this is from Michigan State University, published through EPIC, which is nonpartisan. We worked really hard to make this not political, that this isn't a one side versus another. This is an investment in all of our kids across the state of Michigan, that we truly believe that investing in our bilingual programs, in our English language development programs, is going to raise literacy and opportunities for every kid across the state. And so you see there a visual that shows that Michigan changed our Section 41 model for funding English learners to a weight compared to all of the other states across the country that use a weighted formula to invest in their English learners. We're dead last in Michigan. And so you can see that that's a really clear visual of we had a lot of work to do. We still do have a lot of work to do. The final tool there that we used is on the next slide. And this is my own district. So at West Ottawa Public Schools, we created a handout to make it really transparent and visible. How much does it cost to fund and fully staff a program? At West Ottawa Public Schools, I'm sitting in our new building right now. We are opening this year our first two-way dual language program in a full school building. Los Lagos Bilingual Academy became a reality this year despite the current times, and we're investing millions into growing our ELD program. You can see in fiscal year 21, we had 12.5 ELD teachers, and today I have 28.5, with only a slightly larger number of total English learners. So you can see that we're investing here. We're trying to be a beacon of, we can do this. You don't have to wait for the funding. You don't have to wait for the policy, that we can do what's right for our kids at any time. Our kids need us and can no longer wait. And so despite some funding might go away and this guidance has rolled back, we're really trying to show the progress that can still be made. And then the next slide has, so what did this advocacy result in? The impact here in Michigan is we have new policy written in legislative language tied to this grant, Section 41, that has required English language development instructional models and weekly minutes, requiring a minimum of 150 minutes of ELD weekly for all English learners and an additional 150 minutes for our newcomer students in those very early emerging levels of English language proficiency. And we also saw approximately a 25% increase in funding within a year. So we moved from about 40 million to 50 million. We've estimated that it would take about 400 million annually to fully fund our programs, but progress is progress. We're moving in the right direction. We're still waiting on our Michigan budget to come out, and we're hopeful that this funding will remain, and time will tell with that. But I want to encourage all of you on this call, keep doing the good work. Our kids need us all, and no matter your role in education, we all have a sphere of influence to be able to move this work forward for our kids. So thank you for having me, and reach out if you have any questions.
Pam, thank you so much. I really appreciate the in-depth information that you share, and I really applaud your efforts in Michigan and for really raising the bar to really show our nation also how we can, how important it is to that we strategize and that we're thoughtful in that partnership. But also, you mentioned that this is not a red or blue issue. This is an issue that it's important for our country. So all our students who are English learners receive the education that they need in the way that they need it. So I appreciate that. Thank you so much. So now I know we're running out of time, but and we also received over 100 questions before the webinar, and we really were thoughtful on sharing those questions with the panelists. So most of those questions were addressed through their presentations. We were very thoughtful on doing that. But right now, if you have a question that you want to raise, please put it in the chat. I have a question here. So how does this affect Puerto Rico? If maybe David or Michael would like to take that question. Let's see. Or we can come back to it. Another question.
I was waiting to see if Michael had done any enforcement activity there in Puerto Rico, because he was at Department of Ed a lot longer than I was at the Department of Justice. But yeah, so Puerto Rico and this is my general understanding, it is, situated, a little differently, but these Title VI, for example, is a federal funding, statute. So Puerto Rico receives funds from the Department of Education, among other federal agencies. So they have, obligations under Title VI. What does that mean now that the guidance is withdrawn? As Michael shared, previously, and others have shared, it doesn't change the law. It doesn't change, the obligation still, regardless of the withdrawal of the guidance, whether or not, the EOA would apply. I believe it would apply the Equal Education Opportunities Act of 1974, helping to expand and fortify, the basis for appropriate language services. And Puerto Rico itself may also have additional laws. California has additional laws. Texas has a law that says you can't segregate English learners for extracurricular activities and PE and those types of courses as well. So, those Puerto Rican law and state laws, could afford you even greater protections than Title VI and EOA and other federal laws.
All right. Thank you so much, David. Another question here is for Pam. This one is specifically for you. And it says, when you talked about the ELD minutes, is that now a requirement for Michigan under the Department of Education?
Yes, it was written into the legislative language for districts receiving Section 41 specifically. In the spring, the policy was made public and published, and it's expected to be implemented this year for all LEAs who are receiving that funding. So it is tied specifically right now to a single funding source, but Section 41 is a large amount of money in comparison to what we get for Title III, for example, federally. And so most of our districts do receive this.
Thank you, Pam. Here's a question from Henry. What can educators do to ensure that there is equitable access to instruction for multilingual learners across the district? Let's see. Marta?
Well, yes, one of the answers is, of course, local advocacy, right? Local advocacy to ensure that every multilingual learner, whatever language they may speak, has access, right? Hopefully one day they will have access to a biliteracy program by default, but at this moment, at least access to the services that the federal law, of course, indicates that they have. The English learners have rights to language services, etc. And I think that it starts at the local level, but also we need to press on the state to develop guidance, to develop frameworks, and to reaffirm this necessity to ensure that all learners, all multilingual learners, receive an effective education. And hopefully one day it'll be in the language that they speak.
Thank you, Marta. That is very helpful. And again, it is all about organizing and building those partnerships with others. I think, as you saw today, the information that Marta and Pam share, it's been very strategic and truly working in collaboration. That's how we are able to work and advocate for our students. Okay, I know that there's probably more questions, but again, we will be sharing all the links that we shared and the contact information of our panelists as well. Now, I'm going to pass it to Margarita, our president, Dr. Margarita Machado, to share some final thoughts and share more information about our upcoming events. Thank you.
Thank you, colegas. Thank you so much. So as we come to the close of this webinar, I want to thank each one of you for engaging in this urgent dialogue. We heard from voices across several states who are reminded us of the real immediate just consequence, right, of this rescinding the Dear Colleague letter on language access. And I think what we learned today makes one thing clear, at least to me, that this is not an abstract policy debate. This is really about our rights, about our lives, about our future, and the future of the more than 5 million students across the United States. There's also the other thing that really has come up here, and I want to thank everyone that presented, is that there is still much more we can do. Hay esperanza, hay muchas cosas que podemos hacer. We cannot wait. Let's be proactive, let's be intentional, right? And then we cannot take this lightly because there's so much at stake. Our fight is definitely bigger than a single letter and a single decision. This is about protecting our free speech, defending our civil rights, and really insisting that every single student has the opportunity to succeed without giving up who they are, who we are as a community. And the time to act is now. And, I think the other thing that really I'm reminded today and always, but today specifically, is that you're not alone. We have several organizations here in different states that have shared what they're doing. And I think that part of doing these advocacy efforts is the intentionality of reminding ourselves that we are not alone in this effort. Please reach out. Please reach out to any of these organizations, any of these colegas, to us at NABE. We're here for you. Right? Let us take this knowledge, this passion, and these strategies that were shared today to really transform our advocacy at the local level, where you are in your classroom, in your schools, in your communities, into policy, and then everyday practice. Advocacy is a process, it's an everyday practice. So on behalf of the National Association of Bilingual Education, I really want to thank our distinguished speakers for their generosity, their leadership. Marta from Californians Together, Michael from Educational Opportunities Project, Lina from Unidos US, Pam from West Ottawa, Jeff from TESOL, David from the National Center for Youth Law, for being here, for standing with us. And I really believe that together we can continue this fight for justice, equity, advocacy, and, and really continue to fight forward, right? Just to finish, I really truly believe that we're called not only to defend what has been, right, but really to birth and midwife something new together. And we cannot do this alone. We have to do it together. So this is our call to action, to bring forth a future where all of us, our languages are counted and our students and our communities are honored. So before we closed, today I want to tell you that we have another webinar scheduled on November 5th. The webinar is going to be around higher education, and we titled it Higher Education at the Crossroads, Policy Access and Equity. Is going to be November 5th at 5 p.m. Eastern Time, 2 p.m. Pacific Time. Please join us. And in between all of this, we're here for you. Reach out to us. Montserrat, muchas gracias. Nilda and the whole NAVE staff that's here, muchas gracias. Thank you y adelante. We have to defend our right to be bilingual, multilingual, and ready to mingle from Sunday to Domingo, mi gente. Gracias. And we have a survey, by the way. I just wanted to mention, we have a survey that you're going to get, and all of the links will be provided on our website, but also they will be emailed on this survey. Gracias.